Good evening and welcome to the wet December meeting of the Development Review Board. We have a number of things on the agenda. Please sign in if you haven't. And the state of Vermont allows you to be what's called an interested party if you offer evidence, whether it's written or oral. And by being an interested party, that gives you the right to try to appeal any decision, or gives you the right to appeal any decision that we may make or not make. Each hearing we'll call separately, and I will give, we unlike the select board, we don't have a public forum in the beginning. We'll do it for each hearing. So I will ask if there's any input from the public during each hearing. And if you have something to add, we'd love to hear from you. So the first matter on the agenda is pre-sub 2024-03, Matthew Parisi, seeking preliminary approval for a proposed three-lot residential plan unit development. Lot 1 containing a pre-existing duplex, Lot 2 a pre-existing single-family home, and Lot 3 would be common land. Is there anybody on the board who would have a conflict with this application? Matt, okay.
That would obviously be me, so I need to recuse myself from this.
By stating that you recuse yourself, that allows you to leave the board and you can then join the general public. And since you're the applicant.
All
Matt,
right,
do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Is there anybody else who's going to offer testimony on this hearing? No? Okay. Matt, what do you have in mind?
So, Tyler, do you want to pull up the, I think the map probably to start out with, right?
Sure. Yeah,
Of
we
the
do
site
that.
plan.
Site plan. Now, hang on one second. I just want to share this.
Yep.
For those of you at home.
Does it work?
You guys see the screen okay?
Yep.
Tom, can you see the screen? Okay. I'm assuming MMC TV and anybody on there can see the screen at this point, so we should be good.
So these buildings are all currently built. We are just simply, these were built under a previous permit in 2023, along with all of the site improvements you see here. So this is current site conditions. We're just simply looking to separate ownership of the buildings on the existing property. Specifically into two buildings, essentially, 2 units. The front duplex and the rear single-family home, and then all the remaining lands will have common ownership interest. There are rights of way for the building in the rear for water, sewer, power, things of that nature. But yeah, that's essentially what we are. We are just trying to do. We're just trying to separate ownership. Currently, ownership can't be separated.
So these are basically footprint lots,
That's correct.
and everything that's sort of white space is common land.
Essentially.
And do your deeds already say that, or your,
The current deed is still a
one deed for all the
one deed
property?
for all of them.
Okay.
Yeah. There has been, there is, HOA plans, PUD declarations, that Tyler has that you can pull up that basically speak to all of the stuff that we have.
I do apologize. Those were added a little late. There was a little bit of a paperwork kind of mix up there and that I didn't get, and he had sent them to me, but I hadn't, that was like right after last meeting and they just weren't in the original submittals, but they are here. So let me pull them up.
Right.
So sorry
Right.
for the last minute nature of that, guys.
And obviously those dates, since this is just a draft, will obviously have to be updated, but essentially it goes through everything there and so on and so forth. Are Any
Okay.
questions from the board?
That's my job. Any questions from the board?
No. How are you gonna divide are you gonna put deeds on record? How are you gonna do that?
How we're gonna divide what yeah, they're gonna have to be new deeds written, most likely for, or, you know,
I'm just curious.
that's for the lawyers, really.
That's what I'm asking.
Yeah, I don't, that's a great question. I mean, I'm not an attorney, but a PUD, usually you have one master deed, correct?
Well, the way we've worked,
PUD?
the way I've seen it done in the past.
Yeah,
Is you're getting permission from us, if we give it to you, to subdivide.
right,
If you keep everything like it is until such date that you want to separate, that's fine.
yeah,
And then, if you convey a parcel out, then you'd probably have already recorded your declarations and so forth. Then you'd give a deed that would reference the declarations.
I think we'll probably try to get all the legal stuff done as soon as it's approved, just so that there's no confusion 5 or 10 years later or whatever.
Well, I'm looking at
So
this.
do it before, if we give you the approval,
Yeah,
do it before April 1, because, well, it's your choice, but April 1 is the date when the listers will list them separately
yeah, right.
or not.
Right, and we actually do want to separate it from a tax perspective, because it's a partnership.
Right. That's
Well,
what
you have to do that in order to sell them individually.
Right,
But yeah, so you've got the entire piece as part of is the declaration.
yeah,
So that's the land that's described in your declaration. So yeah, so in order to really separate them, you have to put deeds on record.
fair enough.
Any other questions from the board?
No.
Do we have is Matt on? He's not.
No, he is not here at
Okay.
all. Yep, he's the only one that let me know he's not.
Is there anybody from the public that has questions or wishes to offer some evidence about this? Nope. Matt, anything else from you as applicant?
I think that's all of it.
Okay,
Yeah, Tyler did make some recommendations. About things that the staff thought that we needed. And I don't know if you've got that in front of you, but, and Matt, have you addressed that?
Well, we had talked about this at the last meeting, essentially. Kind of like other. This is not a traditional, I mean, it's a PUD, but it's not the only way to separate ownership is through a PUD here.
Right.
So a lot of the items like a landscaping plan, well, the project's already done. It's already been approved.
and is there some landscaping?
Yeah, I mean, there's
Okay.
essentially on the west side, which most people are worried about because of where the driveway is, for headlights, there's a bunch of lilac trees or bushes and, there's 2 maple trees and some apple trees. So that was like the biggest complaint from neighbors when we were doing it. Provide screening, yeah, so screening in a parking area, that's also provided by the lilacs and the maples. Stormwater plan, there's no stormwater plan in place. This is essentially, we built dry wells to help with any extra runoff. We added gutters that go to those dry wells as per a neighbor's request. What else? Easement widths for lots 2 and 3.
That's taken, I believe that's taken care of.
That's taken care of. We
That's
figured that
already-
one
That
out.
was already in there. I just couldn't see him.
And the grading, I think, is also shown on that site plan as well. Letter from Richmond Fire Department. I had to speak with them when we were building the house back in the previous permit and they were okay with it. But I don't have one for this permit or application. But essentially nothing's changing from what's already an approved use.
So it's the front building that was pre-existing.
Well, so we built this under when the the village, what is it, the village residential,
The VRC
right,
regs.
the VRC regs changed last June. We built this because it was just a administrative permit. So we built the second primary building here.
I see.
So that was all done administratively approved, buildings built, permit was closed out this June. And then we wanted to separate ownership, since like my wife and I actually basically built that house with all our funds, but that property is owned in a partnership with other family members. So,
It is kind of weird. It's the only district that allows you to have two principal residential structures
one lot.
on one lot without having to do a PUD. And to date, this is the only application I've had that's availed itself of that particular part of the regulation. So there's a lot of stuff that's kind of unique to this particular project that you wouldn't necessarily see in other districts, just because it's not allowed.
Okay. Any other questions from the board? Roger, you satisfied?
Yeah, I think so. I'm just trying to make sure I understand. There, unit one is a duplex
yep,
and unit two is a single family.
correct.
So you're gonna have three, or you have, three living units here.
Correct.
And that's not gonna change.
That's not gonna change.
Okay.
Nothing physically on the lot is changing at all. We're just separating ownership, but keeping the duplex as a rental property.
Okay.
And it's all on town water and sewer.
It's all town water and sewer.
Okay. I have nothing else.
Again, anything else from the public?
So the paper here says you guys want to change the zoning from agricultural zoning to what?
That is I think that's a different
It's a
application.
different,
Oh,
that's
different
later in the
application.
agenda,
Yeah.
yeah.
We're not there yet.
This is the number one, yeah.
I'd entertain a motion from the board.
I see no reason. I move we approve.
Second,
Second.
all in favor?
All right.
Aye. Thank you, Matt. We have up to 45 days to get a decision out. We'll try to do it much sooner than that. Appreciate it. Thank you.
Were there any conditions you guys wanted on that or just as?
No, we've addressed the conditions that you have, and I don't see any others in here.
Okay, next on the agenda. Jessica and Michael Stores. Sipes, I'm sorry, Jessica and Michael Sipes. 60 Wolf Lane, SKP 2024-04. The applicants are seeking to remove a restriction from the building envelope of lot 7 of the Wolf Lane subdivision. The lot's building envelope is currently restricted to agricultural uses only. Is there anybody on the board who has a conflict of any sort with this application?
No.
Nope. Okay, want to come on up?
Yeah, please.
Please.
I have printouts, if I can give you, they're the same things I submitted more or less, but I highlighted because they're,
We've already
Handy.
looked at everything that,
okay,
we should have looked at everything that was.
all right. I
If
can
you have
kind
stuff
of
that's,
direct you toward.
if you
the
have stuff
point.
that's new, that's another question. Is there anything that you want to submit, that
Let's
you want to
see.
submit that we haven't, that
Well,
you haven't given to
I have
Tyler?
and the map, I don't know if that's helpful for you, and I'm not sure was the judgment order submitted in there.
The judgment order wasn't included
Not.
with your.
I have a judgment order that I can
I would like to see that.
Okay, yeah. I have and the only other difference is like there are these crazy site plans, because it's for the whole subdivision, and I just highlighted like the relevant portions for you, if that's useful, but I don't have to give that to you if you don't want that. So, and then I highlighted here. I have one for each. Yeah, sure, okay.
Yeah.
Well, I gotta dig through the packets, the only one parts of it.
You have a lot of items here, so if you have all.
And I'm not even gonna talk about all of them,
Okay.
unless we want to.
No, I just was curious because if you did, it's just gonna be easier to have paper for that.
Yeah, well, I can give you the paper, it's fine. When I re-looked at it this morning, I realized like a little highlighting point in the right direction was useful.
Okay, Will there be anybody else that will be giving testimony on this application? Okay, well, let me swear you both in then. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
You as well?
Yes.
Thank you.
Here you are.
Why don't you tell us what you're seeking to do with this application?
Okay, sure. So first, my name's Adam Miller. I'm with Pease Mountain Law, and I'm here on behalf of that. Well, Sipes, Michael and Justin Sipe here. And to clarify, we are interested in discussing the current allowed uses of the their property, because there's some discrepancy and we get mixed guidance on how they can currently use their property. The way to come before you, I understand, is through a subdivision sketch plan review, but there's no subdivision to discuss at this time. And also the agenda says we're trying to make a change, which is inaccurate. We just want to know how we should understand what they can currently do with their property so that we can plan future.
So we can't really give an opinion.
Yeah, we're not looking for anything.
Seek, I mean, we could discuss if you're coming before us because there's something attached to the lot, like a restriction that you want to get rid of, then that would be an amendment of an application. We can discuss that.
Okay, I'm not sure that we need an amendment. We don't quite understand what the restrictions are and have received mixed guidance from the town. And so I think if we could get a non-binding kind of nudge in how we should.
Why
approach
don't you
property.
discuss, why don't you tell us what it is that's troubling you?
Yeah, okay, so this is their property is on, I think, you want to pull up Tyler.
Which one you want?
C,
C
where
or
where
B?
are we?
You are item C.
No.
Item two.
Probably,
So that's your
Probably-
exhibit B,
E,
exhibit E.
yeah. Okay, may I point at,
Yeah,
we're not highlighting, let me come up here and
On this.
this is their,
Hang on one second. Sorry, I need like a jumbo monitor for this thing.
so this is their property here, it's this area, it comes up here, it goes up like this, comes down to, this is Faye's Corner, and this is the Heinsberg Road.
That's all one lot.
It's all one lot, yeah, it's 14 acres. They bought it in 2015 as an undeveloped lot and have since put a bunch of effort into it. It's currently 4 buildings. It's being used for residential use, commercial use, and agricultural use, all with town permits and state permits. The property, let me see, when it was originally created slightly differently, and it was created as 2 lots, and this is the plat that was recorded in 2008, when there was an amendment to the subdivision that kind of broke a large parcel into a couple different pieces and merged it with this parcel. And so their parcel here has 2 building envelopes on it. There are currently permitted buildings and uses in both building envelopes. The conflict that we're here to discuss is this building envelope here. And there is a language.
What's in that building?
That building is currently, well, there are 2 buildings there currently
Yeah,
that are permitted. There's a shop there. It's an art studio, a photography studio. It's permitted as a commercial use as part of a cottage industry associated with the residential use.
which structure is that?
The structures, I
It's
don't
a
believe are
large,
shown.
like barn looking building. I
It's
guess
a white,
modern
it's a
barn.
Pretty
white
modern,
barn.
right?
Yeah, a modern looking barn, I suppose is the best way I could describe it. And then next to it is a hoop house, like greenhouse, which is permitted for non-agricultural uses. And so it has 2 buildings there. This has a primary residence and an ADU on it. And then there's agricultural uses throughout. The parcel, when it was all created, has a number of restrictions on it. Primarily that all the development has to be focused toward the building envelopes, and the rest of the land is all conserved in a number of different ways for state permits and
Conserved, what do you mean by conserved?
Well, can I show you the restriction here is that when this lot 7 was created, it was restricted so that no more building envelopes could be placed on lot 7. And the development is focused on, well, obviously building envelopes focused on the primary uses on the lots toward building envelopes. And so if
You want me to pull up the decision?
no, not quite yet. If you could pull up, the 2006 DRB decision, I think, because this is the crux of what,
Subdivision approval.
yeah.
So
Sorry, I didn't
really,
write the exhibits
No,
on.
that's right. The one that we have here is,
Yeah, if you go to page 2,
yeah, findings of fact.
and so
I know the
this is the
condition.
restriction that, that this number 3.
This
here.
one. Yep.
So it's a portion of lot 7. Lot 7 was like the larger parcel that got merged in with theirs. Adjacent to Heinsberg Road is defined by a line. This is the part that we now own, is what they're talking about here. The portion of lot 7 adjacent to Heinsberg Road shall be preserved without any building envelopes because it contains septic and disposal fields, except for the proposed building envelope for agricultural use only depicted on, and there's some site plans. Any other construction on this portion of lot 7 would interfere aesthetically with the views of the home sites on the remaining lots and or restrictions for the homeowners association for property or properly managing the common facilities such as the septic.
What exhibit is that, Tom?
That is
So-
exhibit, hang on 1 second. That is exhibit A, item 2, exhibit A, right?
Page out.
So I was on the board when that
Yeah,
subdivision came in front of us, and I remember somewhat the discussions that took place regarding that lot. And I seem to remember that it was because of all the septic systems and everything else on there that it was finally decided that that would be stated as an agricultural lot.
the lot 7.
Yeah,
So.
I don't have a clear, it's been a lot, many
Yeah,
years.
I've dug through this. If I could now go back in the history in the year before that to just put this in perspective, this language, because I think there are 2 ways of reading that. And that's what I want to ask you about. And I'm sorry, Tyler, if you'd pull that back up.
Which one did the DRB decision?
Yeah, so the one way to read this is that what number 3 here is doing is saying that lot 7 shall be preserved without any building envelopes for some reasons, except for the one building envelope. And the other way to read that is to say that the except part about the building envelope is imposing a restriction on the building envelope, that is for agricultural use only. All right, and I think that's where this kind of like poorly, or I don't know, inartfully drafted paragraph is led the town to give guidance, in both directions. And I think it would be helpful for my clients to know how we should understand this, or how you might understand this if an application were to come before you, so we can know what kind of effort we should put into developing this property or investing in this property. Okay, and I'd like to put this in context. If you could, Tyler, I guess, do you have the judgment order?
I don't, I was trying to see,
Okay.
if I have it downstairs, but it wasn't part of your submittal.
Sorry, I've now scattered my stuff all.
The one that you just handed?
Yeah.
It's a hard copy.
So to put this in perspective, this subdivision was controversial apparently in 2005 and 2006.
I think
and went before
it dragged on for a year.
Yeah, went for the E-court or.
And obviously went to E
Yeah,
court.
and I think it's very early
That
days
circuit
of the
passed away.
E-court, yeah,
Signed it.
yeah.
So we can't ask him about it.
So the second time I went before the E-court, the subdivider and the town were parties, and they reached an agreement, and a settlement agreement, which was approved by the court. And paragraph 3 in here is what they're getting at, and this is what the DRB later held their hearing and issued that opinion that decision that we just looked at.
No,
And
but
so-
we issued that opinion, our final opinion, based on the judgment
Yes.
that was in front of us, including that language
Yeah,
in
you-
paragraph 3.
Yeah, and it's very similar. The DRB decision tracks very similar You know, the only difference in here is the DRB decision was trying to define what portion of lot 7 it applies for. That's why they were saying that first sentence there talks about like what portion of lot 7. That's the change in there. And then the only other change is that it drops the restriction on no residential use, and here is not in that decision. But what they were talking about at the time is the site plan that was before, which is that's maybe the first one.
No, so first one is the subdivision approval. Site
Okay,
plan. is
two.
big.
Yeah, let's pull that one up. So what they're talking about here is this site plan, which is what was before everybody in the early days. And the difference between this and the plat is largely here has a label on this. And it says proposed building envelope for agricultural use only, no residential use. Okay, which is language we've just seen. And so what the E-Court here has done, or what the parties agreed to, was there are no building envelopes on lot 7 except for the building envelope. And then they identify it by the only way you can identify it, by putting the label on it. And they say, and I quote, proposed building envelope for agricultural use only, no residential uses. And we know that they're quoting that because in your decision, the DRB's decision in 2006 that followed a couple months after this, if you can go back to that one, Tyler.
Yep.
Thank you. On the first page, in the finding of fact, number 5, the DRB discusses this and they say the size of the, and they use the exact term in quotes, proposed building envelope identified for agricultural uses only, no residential use, and where it's located. And so the DRB here is saying this is the label, this is the way that this building envelope is identified on lot 7. So they take lot 7 and say no more building envelopes here, except for this one building envelope. And that's where all development is to be directed, and no more building envelopes anywhere else on lot 7. And I want to put this in context of what the town was doing. This is a municipal zoning, right, that we're dealing with. And, you know, in 2006, the town didn't, like today, doesn't have any authority to regulate agricultural uses through municipal zoning. And so to say that there is only agricultural uses in the building envelope is the same uses that you have outside of the building envelope, and there would be no difference here. You know, they have the right currently, because the town can't enforce zoning for agricultural, to put, you know, crops inside or outside the building envelope, or barn inside or outside that's used for agricultural purposes, or fence or whatever. So there's no difference for the building envelope unless, you know, that's not exactly what they're talking about. They're talking about putting the stuff that the town can regulate has to be pushed to the building envelope, but not outside of the building envelope. This has come before the town in 2 instances prior to address what can be done in this building envelope. And on both instances, the town has approved, the DRB approved the commercial like art studio in here, that's now the modern barn. And then secondly, the zoning administrator approved a, you know, the hoop houses, and specifically said that it's allowed to be used for non-agricultural uses. So this is consistent with the way that the town has viewed this twice in the past. And the other, I think the other thing I'd point to at this early phase in 2006 is that the label on that building envelope is a use restriction, right? It says it's to be used only for agricultural purposes. There are buildings on there now that are used for, you know, commercial uses. But the buildings there, regardless of how they're being used, don't have any impact on, or any different impact on the wastewater system, which is in a far distant portion of this subdivision. And they also don't have any impact on the view shed, because the building, you know, that barn, that studio that's currently there has the same visual aesthetics, whether it's used for a bar, you know, for art studio or cows or people, or, you know, whatever your use is, it's the same aesthetics. And I think the best way to read this kind of convoluted paragraph It's that what we're trying to do is direct the development that the town can regulate to this building envelope, and that there are no building envelopes outside of that on this parcel. Is that a reasonable interpretation so that my clients can plan this, plan the uses of this property, or is that an unreasonable interpretation? That's kind of the nudge we'd like. And the implications of this are kind of strange, because if it's now a allowed use, like they're only allowed to use this parcel or this building envelope for agriculture, it means we now have non-conforming, legally existing but non-conforming uses of these existing structures. So if they want to expand the structures or relocate the greenhouse footprint or change a use in that, they have weird implications of, zoning violations, or would prohibit doing those. And also if they want to change their property in other ways, or it'd be helpful to know so we can understand how to invest in this property. here.
Adam, let's cut to the chase. What do your clients want?
They want to know if this.
What do they want to build here?
They don't want to build anything right now. But one idea, what initially brought this up, was floating the idea of repartitioning what was combined into two lots. The 12 acres and the 2 acres combined into one, and seeking repartitioning that. We foresaw some challenges with that, but not municipal zoning. Because they have plenty of road frontage and whatnot. There's some declarations, some state permits, that are challenging. But if the town zoning is a hindrance on this, it would be helpful to know that now. But also keeping the parcel as one substantial investment into this property, and understanding if they have non-conforming uses of this, then maybe it's not wise to keep investing in that portion of the property and invest in other portions of the property.
Tyler?
Yeah, I think a little bit more context with this, because I've had the conversation with both Sipes and Adam, and kind of as to how I interpret, this DRB decision in the court judgment order. And I think that might be part of where we're having the conversation, because I read that and with all respect to previous zoning administrators and what they did or didn't allow, I read it, at least to me, it's pretty clear that it's saying that and this is the advice I gave to Adam and the Sipes as well, is that this is restricted to agricultural uses only inside of that building envelope. So if you have a farm that has wraps, so you would, first of all, to get that agricultural exemption, one thing I would look for is, are you a farm with the state? So as long as you have RAPs, required agricultural practices, you're a farm. You do have some other uses that you're allowed through ag, which is like accessory on-farm businesses and other things that you could do that may not make these things legally non-conforming or not. But in terms of, let's say, if you wanted to put a residential structure in there, I would see, at least how it's read here and in the court judgment order, that is restricted. That's not a use that's allowed, because the language for the envelope says, as was noted there, shall be preserved without any building envelopes except for the proposed building envelope for agricultural uses only. So to me, that's pretty clear. That would rule out housing, that would rule out, most of your commercial office stuff. If there's some office that's related to running a farm, if there's an accessory on-farm business, which the state recently added a lot more allowed uses to farms that weren't traditionally in there, those types of things would be allowed. They actually wouldn't even require a permit, provided that they have an RAP. And there are other agricultural uses that would be allowed outside of that, but in terms of structures built, and again, I think you could build ag structures outside of that building envelope, because it's ag, it's exempt, it's exempt from zoning. The issue would be inside of that envelope. It's also saying, I think, that you cannot have anything other than ag buildings.
I don't know why we have a building envelope then. If it's the
That's
same-
not my
yeah.
call to say, but.
But what was
Well,
the town trying
One
to do?
reason we have a building envelope is our ordinance requires every lot to have a building envelope. So the original subdivider, Bud Ryan, had to show us a building envelope.
can you show us on the site plan again where the building envelope is? And does it conform to the building envelope as determined in this, I guess this is the findings of fact, the size of the proposed building envelope for agricultural use only is a polygon approximately 300 feet by 200 feet. Is that what we're talking about?
Yeah, it's well, in all of the plats that, so this is their draft that the court was reviewing, the DRB reviewing, and the same building envelope exists on all of them. The difference between here and, the DRB ordered the applicant to go make some changes and put it in a plat to bring before the chair for signature and signing. The only differences with the plat, really the relevant ones, is that they remove the restriction proposed building envelope. That label disappears from the plat. The envelope's the same.
Okay, so my point is that the area that's shown there is the area that is restricted to agricultural use according to the opinion or the whatever this is from the DRB in 2005. Is that correct?
It's the same building envelope from the site plan to the plat. Yeah.
Right. And is there a building within that envelope now?
Two,
Right, and that's where the white barn is.
yes.
Right, so what is your argument that it should not be used for agricultural only?
I think it can be used for agriculture.
Yes, but what is it that you want to do in addition to agriculture? What is your argument for going beyond that?
I think that why do we want to do it, or why should we be able
No,
to do it?
what is your complaint about having it be
I
agriculture?
think we're having trouble figuring out what you're after here.
Yeah, we're trying to find out what you want to do. This is kind of, let me tell you what my issue is here. Usually in a sketch plan, you come to us, I mean, you've been through this
Yes.
before. You come to us and you say, this is what my clients want to do. What do you think about this? Is it possible? So what you're doing is you're coming to us and you're changing the rules. You're saying, what can we do with this, guys? And so, we're sitting here trying to decide what you can do with this. And I don't,
Yeah, it's
I've
a
been on
great
your
point.
side of the table.
Yeah, it's a
before.
great, can I answer that? Actually, if you don't mind.
sure.
So I'm kind of frustrated with that process too. Really,
Yeah,
really what I'd like to do is just have a conversation. So we've talked about like potentially, what brought this up was when we talked to potentially a subdivision with Tyler, but before we go hire engineers, and if this is like the hang up, then like it's helpful before we hire professionals to understand like just how you might do this. And so my request was to just have an informal discussion, and the process to get before you is sketch plan.
Okay.
But that's not really, but we don't really want to talk about like all the subdivision
So-
regulations or anything.
So I have a couple,
Let me just finish,
Yeah.
if you don't mind, Matt.
Yeah.
So my point is that I agree with Tyler. What we have in front of us within the 4 squares is what's written here. And I'm saying, well, it sounds like this is pretty much cast in stone. If you want to do something in it, to change this, then tell us what it is you want to do. But right now, I think that what we have is an area that's set out here very clearly. That's you can build agricultural buildings, but that's all you can do.
That's helpful. Thank you.
And that is my position at this time, unless you try to convince me
I'll
otherwise.
go, why aren't you?
Yeah.
Yeah, I'm more than happy to jump in and speak to why we're here. I don't want to waste anyone's time on board. And
No, we're here. You're not wasting our time.
Yeah, okay. So, we came in front of the board in 2016 with this very question about this area because we were exploring building our home down at the studio. And there was a pathway that the board laid out that we should take at that point. And then we went back and discussed it with our family, and we changed our plans accordingly because the clock was kind of ticking with the builders and everything. So we had to kind of move in a different direction. We built a home. Since then, my mother's passed, and the home was built with my folks. Change of circumstance. My father's kind of growing on and looking maybe to change his living situation, get into assisted living and such. So we're at a junction right now, we're kind of exploring getting ahead of everything, and we're exploring wanting to subdivide where we built a home on the 1.74 acre lot. And making a new lot where the studio is and building a small home next to the studio, residential. Um, That's what we're exploring, the idea of that. So when we talked to the DRB back in 2016, there was a pathway created for that at that time, after discussing with the city lawyer. And there's a lot of history to this development, as Mr. Sunshine was alluding to. I think a lot of this that got baked into this rule here came from a neighbor who wrote a letter worried about two issues, which was their septic and their view shed. Since then, we're on great relation with all of our neighbors on Wild Apple and Wolf Lane. No one there has voiced any kind of concern about what we're talking about. We were very open with everyone. So that's
Michael, I'm wondering, and I'm just wondering, and I don't know the answer, but our decision, the DRB's decision, back in November 11th, 2015, was based on a court settlement, a judgment order from a court. In my mind, I'm wondering, can we change something that's dictated by a court order?
well,
And maybe you need to go back to the court and ask for relief from the court. I don't know. I'm just throwing that
I
out
do have a
there.
little bit of guidance on that, because I looked into this issue initially. And the advice that I got from the town attorneys, because these conditions, he was trying to figure out the vehicle, how would you go about lifting this restriction?
Right, that's what I was
And
getting at.
because of what they would have to essentially propose is a new subdivision. Essentially, you have to go through preliminary, preliminary and final really to do it. And what the board would have to use is the Hildebrand test and the Stowe Club Highlands, because the original underlying subdivision, part of the reason that this lot was allowed to be created was with that building envelope. So the only way to remove that building envelope, the only tool that you have is the Stowe Club Highlands and the Hildebrand test that the board would have to apply to see whether or not you would be allowed to modify that particular lot.
Did Dave Rule think we had to go back to they would have to go back to the
He didn't
court?
say they'd have to go back to the court, but he said they would have to come back and propose a new subdivision to get this removed, and what we would have to use would be the Stowe Club Highlands or the Hildebrand test to determine whether or not this restriction can be removed on the lot, because it was essential to its creation. So we have to determine whether or not using those tests, and I'm not an expert on those tests by any stretch.
No
But
one
that's,
is.
but that's what you would have
Well, I
to,
mean, if I-
that's what
I-
you would
if I
have to
may.
use.
Well, one, we're already using the studio as a cottage industry outside of the, outside of the permitting we're talking about. So it's already kind of been pushed as far as the permitting that cities done. But back in 2016, the advice of the DRB at that time was different. It was, we see a pathway. We talked to the city lawyer. We'd like to go in front of the select board and have them decide, then come back to us. That was the pathway then that the city lawyer, I forget the gentleman's name, Mr.
Town lawyer then, Mark Sperry?
Sperry, had laid out. There wasn't, it sounded a little different than it sounds now, but, so that's just my layperson kind of interpretation and historical input to.
Adam?
Yeah, respectfully, I think Stowe Club is like that's like a couple steps down the road. What we're asking tonight is, does a restriction exist currently? Which I've heard yes, and I've heard one yes and some maybes. I'm not sure. But so if it does exist, the next step before you get to the Club Highland is this critical, and both the decision and the judgment order in this says it's an agricultural use to protect the septic, which is a distant
Well, also
view
bring
sheds.
aesthetics.
Well, and view sheds, but there's, the structures, so, but that would be another thing that the board would need to decide before you even get to Stowe. And if the answer to that is yes, this is absolutely critical to this subdivision, then you would get to Stowe Club Highlands. So, but we're just at the first step tonight. It would be helpful to know if the board views this as an agricultural only restriction such that we should plan accordingly? Or is this a restriction that agricultural uses are for all of this lot is restricted to agricultural uses except for the building envelopes?
And I do think it's important, though, that he's kind of asking for an advisory opinion on this, which is not really something that we do in sketch plan. I think you
Right.
have to go to preliminary.
I don't
get
think
a
we can
decision
give an
where-
advisory opinion.
No, you can't.
Some kind of guidance of how, if this came before you, you might consider it would be helpful, just so that we don't invest in professionals here. If this is a losing project, or if there's like a reasonable argument here that this building envelope is where the development should occur, not limited to just agriculture, which can happen everywhere else similarly also. That would also be helpful, because then maybe we put together a good application and come back before you with it, and you can make a binding decision on this with the same information or fleshed out information. But if it looks like that's not going that way, it's helpful to know that.
Yeah, I mean, both the DRB decision and the court decision reference, right, the wastewater disposal, the sewage. I haven't seen this anywhere on here, and is this all shared community septic?
Much of it is, and it's down here.
Right, but
And-
usually when the wastewater engineers design it, they design it with a primary, and then in 20 or 50 years, however many years it is, it'll fail and they have a secondary
It's
field.
also way down there.
It's also,
Yeah.
So why?
It doesn't
do
have
they-
anything to do with, but if you read it differently, that there shouldn't be any other building envelopes on lot 7. That makes sense, that they're saying don't put any more building envelopes over there where the septic system is. But this building envelope, no matter what you do with this building
I
envelope,
I seem to remember that it was definitely the board's feeling that no building envelope should go down where the septic is,
that's
obviously.
agreed.
Right.
Yeah. Which is how I read the paragraph, that we're talking about, that really what we're talking about is no more building envelopes on some, because if you read it the other, you get to these absurd, that it has nothing to do with the view sheds and the.
So I can't remember, why did this go to E-court? Did the DRB give a ruling to Bud that he didn't like, and he took it to, is that what happened?
Entirely sure about that one. The first one was because it was something about his prior PRD and whether you could amend a prior PRD or something, which the court said, yeah, go ahead and do it. And then whatever decision the DRB rendered, he must have appealed back, and that just reached this
I
settlement.
think is there something called a PUD or?
There used to, it's a planned unit development, yeah, or a planned residential,
PRD or a
residential planned unit
There was a
development. There's
decision
essentially the
by the
same thing.
DRB that said he was over his lot number and he disagreed with how they were counting it. And so they ended up at the.
Okay.
I mean, I think there's part of an issue there too, is that, it's my job to interpret this and like, what does it mean? So I guess it's, essentially more or less, not the advisory opinions on stuff more or less comes from me, in that I read the DRB's decisions and stuff and say, this is what I think you can do, or this is what you can't. I mean, I think in order for them to get a decision out of you guys, one way or the other,
They've got to come.
they've got to
with an
come for you
application.
for an actual application.
Yeah.
That's the only, and that's what I advise.
Respectfully, sketch plan is an informal, in your process, is an informal guidance on how an applicant should develop their project so that they can bring it back before you for a binding decision. It is just guidance. It's the guidance we're looking for. How should we consider this so that we can bring back an application that you can decide on efficiently? It's the same kind of informal guidance that we're asking for, the sketch plan contemplates. And it's non-binding. We're not asking for a binding decision. Just point us in the right direction would be helpful.
You have any thoughts, Patrick?
Oh, I'm curious if there's anything in the record to suggest how the 2 buildings north of the field road were approved.
Yeah.
You're
I mean,
talking about
those
the
are-
barn?
The
Oh,
barn.
Remember when the barn came?
I remember
in
when the
front
barn
of us?
came before us,
Yeah.
and
Well, is that not in that same area?
It is.
I think this is the studio approval right
So
here.
are we saying that was perhaps an error,
no, that, as I recall,
or was that an agricultural use?
well,
And it was viewed as such.
it was viewed as an agricultural use.
Okay.
Which it probably would be if it wasn't then, it probably is now because of the on-farm, accessory on-farm business.
And look
Has
on
a
the
lot of-
description, it was for storage
It's
of
a-
farm equipment and.
There was there's a storage barn shed off the back.
That was the
that
deal.
has-
We had to have some agricultural use in that building. I remember it was a photographic studio, that's what.
Yeah,
I
we made
remember,
the-
I
yeah.
remember hearing. So, yeah, and we said, let's connect it, we have to connect it somehow to an agricultural use.
Okay.
And that's what we came up with. And now what you're doing with it, I have no idea, but the
Yeah,
point is
because
that
that makes sense.
that's what caused us to make that decision, that it would be an agricultural structure. And if you did something else in it, also, that was fine with us. Now that, I may be wrong about that, David, but that,
No,
And what
that's,
is,
I remember that.
I think that's right here, Roger, number 4, findings of fact.
so what is a non-agricultural hoop house?
it's a hoop house that can be used for other, I don't even know what it.
I don't know
it-
that.
But they wrote in, you can use it for, specifically, it doesn't have to be used for agriculture. It can be used for other things, I guess.
So is a agricultural style building not used for agricultural in a
Yeah, I don't know.
area that excludes all
Where the
the
kids
agricultural.
play, when it's raining out, it's where you keep your like extra commercial.
That's sort of what
I don't
number
know.
4 says in
Yeah,
our,
I-
in
I
our
guess
findings
My
here.
sense, and I know this is non-binding, it's just,
Yeah.
how do I read this? That area is restricted to agricultural use.
Yeah, and
I don't-
these are unappealed decisions, so they're
No,
not.
I'm not looking back, I was just, it's a bit puzzling, but yeah, I saw reference to it being a barn. Yeah, I'd say future use, it made a plain read of the the earlier decision is it's restricted to agricultural use.
Okay, that's helpful, thank you.
That's my, non-binding, it's, this is sketch, this is informal, you're asking a question, how do I see that language applying to
Is,
future use there? That's how I would see it.
is there any comments from the public? Yes, yes, ma'am.
I just wanted to,
What's your name, please?
my name is Diane Leclerc. So if you go back to the map,
The
I can
sketch.
show you where I'm
Would you like
located.
this one or the other one? Which one would you like?
Maybe the most
Um,
recent one be helpful.
Doesn't matter, I haven't moved. I've been there for 32 years.
I think this is the most recent.
So I'm here. And there's just, I think, this little tiny piece that abuts my property. However, you can see that there's Johnny Brook comes along here. The reason why I'm here tonight is because I'm very concerned when I saw that there was that you might have been trying to lift an agricultural and subdivide to put more building of, of other whatever, is that over the course of the time since there's been all of this building up through Wild Apple Lane and Wolf Lane, over the period of time, the amount of water that is coming down the hill into Johnny Brook has gone way high. And I just spent $36,000 in repairing my property after the flood this July. And what I found in talking to other neighbors, my next door neighbor, the Edwards property, and then also the people on Rocky Ridge or Rocky Road, is that, and even then the hills on the other, are the Kings on the other side, that they're like up here. That it's pretty clear to everyone on the other side of the brook that since there's been this development on the top of the hill, that there's not only water coming through the brook the way it always has, but it's coming down the hill and making the water in the brook higher. So we've had a lot more of erosion. So I have a concern that if there was any proposals in the future for what's happening with the brook down the line, how is that going to impact my property? Like I said, I've been there for 32 years, and this is the first time in 32 years that I've had Johnny Brook on my property. And I was very fortunate that it did not enter my house. It just made an island of my house. But that it was a lot of damage. And I know that there was also a lot of damage. I mean, I lost my driveway, I lost a whole bunch of stuff The people on the other side of me have lost probably 60 feet of their property has washed away from that brook. So we're talking like a lot of extra water that's coming through. So that's my concern. And that was the reason why I came tonight, because I didn't know. I was like, yeah, it was, what do you want to do? And also when I saw the static thing that, yeah, I know that the Kings own directly behind my house. So that's kind of like on the other side of, I don't want a house directly on the other side of the brook necessarily, but it's a concern of mine.
So if they were to do anything further with the lot, they would have to have an engineer tell us that there's water to deal with and how they're gonna deal with it.
Exactly. That's what I would hope
Yeah.
for, because I would be very concerned about
I think we would want to know that.
where is that going, that it's changed a lot, and it wasn't just, this time I happened to get it, but the other floods, my neighbors have gotten it. I know that, this time around, Rocky Road had to repair they lost their whole, the drive, through to those four houses was completely, washed away. That was our driveway. And our retaining wall and part of our septic pipe was exposed, and we lost all kinds of stuff. So I'm just, and we just built a new garage in the backyard too, and we had lost part of the foundation. Wasn't the foundation, we were lucky that we were able to save the slab that we had just poured because it got eroded underneath it from that. So it was a lot of damage. And like I said, so I'm just concerned about what are your thoughts about going over there? And I would want some reassurances before something like that happened, because we know that there's already been an impact on us from all of that development from where you are. So, I just want to voice that.
And just to clarify, we're only talking about the building envelope now, not over near your property at all, or any changes over there.
Well, I'm just even in the future.
Yeah,
just
yeah, sure.
like
It's a good concern.
anything up there, it's all coming down that hill at this point. And I don't know that anybody really realized that.
Of course, we've had more water lately than we've ever experienced before.
True, but even.
Tonight included.
Even before the historic rainfall, we have seen more erosion, a lot more erosion since the development. So it's compounding it at this point. So.
Thank you. Anybody else on the board want to jump in, or? I mean, I can't say that we've reached a conclusion in any way, but we've
See how
given
the
you
wind
our
blows.
thoughts.
That's helpful. We appreciate it. It's helpful understanding.
Whatever you do, if you're gonna propose something else, you're gonna have to have someone deal with stormwater.
This whole area is currently subject to a stormwater permit that is noted on the most recent plat that impacts all of these properties except for inside building envelopes. The building envelopes are exempt from the stormwater permit, or in that aspect, similar to, well, maybe similar.
So if no one else on the board has any other thoughts,
Thank you.
we'll leave you with what we've said, and that's all we can do at the moment.
No, I appreciate it. You've been generous with your time.
Thank you.
Appreciate it.
Also, I made a note, if you do come back for us, even though you said nothing will impact those systems way over there, we should have an engineer tell us that.
Noted. Thank you.
Okay, moving quickly onward.
You're up.
Am I unmuted? Can you hear me?
On to
You
Village
are-
View Condo Association, 90 East Main Street. SKP 2024-05. The applicants, Village View Condo Association, are looking to subdivide one lot from their property. This is a sketch plan, correct?
Sketch plan, that's correct.
Sketch plan.
SKP is always sketch plan.
So who's appearing for Village?
We are on Zoom right now.
Okay.
Yeah, I'm on Zoom. Hi.
Oh, wait, let me, is there anybody on the board that has a conflict on this one?
I am an abutting property owner, Matt Parisi. I'm an abutting property owner. I've also been in discussions with Village View to do a boundary line adjustment to purchase land for a potential PUD in the future. But I'm not part of their application currently. They've taken this on upon themselves without me.
So since this is a sketch plan and we really don't make a decision in sketch plan, I don't have a problem with that. Does Village View?
I don't have a problem with that.
Okay. First question, who's speaking for Village View?
This is Leanna Schneidman.
She's right here. She's on Zoom.
Okay. Do you speak for the whole condo association?
I'm trying
Because-
my best. Yeah.
Well, the reason I'm asking that is as a condo association, for a condo association to change the condominium and convey land out, which is what you're basically going to ask for, it needs the approval of the condo association. Has this been-
I had all 9 members of the condo association sign the paperwork for this application. We've all met. We've discussed the property line. And
Thank you.
I'm the
That's the
representative.
answer I
moving
wanted to hear.
forward. Okay.
Why don't you tell us what you have in mind, please?
I think we're just kind of looking to figure out if this is possible. I think originally the Village View condos, there was supposed to be another 4 units down there. I don't think I submitted the paperwork that shows that, but so yeah, we're looking to see if it's possible to subdivide that, and then we would probably get the land permitted for, residential up to as many units as we could, 2 or 3 maybe, and move forward with the process of selling it, or talk further with Matt Parisi. We're just kind of still in the early stages of figuring out like what we need to get this under investigation.
This condominium association, this all took place in the 60s, didn't it?
I think it was built in 84.
84?
Yeah.
Okay.
Based on all my popcorn ceiling.
Good way to tell. So, Tyler, did you have any thoughts on this?
Other than my notes, it's hard because again, this is, I go with the app, it's sketch plan, so the bar for what you need to submit is fairly
Low.
it's fairly low. I do have some concerns, I think potentially that you might want to look at and see an E&S plan for how would that, given its close proximity to other properties, that if this is developed, how do we want to control for erosion, sedimentation during construction? Do you want to see engineered E&S plan? Do you want to just have them put some silt fencing in and call it a day? There's considerations of what you want to see for stormwater. I will note with the home act, now this is all obviously, everything right now is at a certain place in time. As a result of both the Home Act and Act 181, any lot that's served by municipal water and sewer by rights is allowed 5 units per acre. And any structure that's a single family, be it a single family home or whatever, that's a residential building, is by rights allowed 4 units. 4 units. So anywhere you can put a single family home, you could put 4 units of housing. So in theory, you could purchase that, you could do a PUD, provided that you can meet minimum lot sizes potentially, and then you'd have to go from the Home Act to determine how many units.
How much land are we talking about here? What's your
This
proposal?
is blue area, I believe here, David, which is,
I mean, it's about 13,000 square feet.
and in this district, VRC,
You can do 5, it's, the way it's done right now, you could do a duplex or 2 units.
I'm just trying to see what the density is.
1 unit per 5,000 square feet.
Which would make sense.
13,000.
One unit, which can contain how many residential
Well,
units?
see, and that's the
It's
confusion here, 'cause-
it'd be interpretive. So if you were to somehow, let's say, and again, you'd have to make sure you had enough land to do it. But let's say you put a PUD on that, right? Assuming for the sake, I haven't looked at this to see, but assuming you meet the minimum lot size, right? And you wanted to condense it and put a bunch of like small little townhomes there and like conserve the rest of the land. Anywhere you put a single family home, you can have up to 4 units of housing in that particular building. So in theory, if you're allowed if you have enough acreage to do 4 single family homes,
That's
by
16.
right, you would be allowed to have 4 units in each of those
See,
buildings.
have we gotten guidance on that? Because the
No.
way I read that is that it's a unit is a home, so you would be allowed for whether it be a quadplex or 2 duplexes or 4 standalone small
But
cottage.
4 living units.
4 living units. That's how I read that. And
I would really have to, a lot of this is
Yeah.
brand new. I haven't had any applications yet that have tried to avail themselves of it.
We've had this discussion before about what is a unit and what is a
Yeah.
residential unit and what is a dwelling unit and
Because
Units
with
are
a PUD, you could propose, assuming you had enough acreage, you could propose for single family homes in theory, right? But
Not on this lot.
assuming
Yeah.
you have the acreage to do it, I don't know if you do.
yeah, if that was 25,000 or 20,000 square feet, which is like 0.4 acres, they would be able to put 4, the way I read it, they'd be able to put 4 units. Whether that's a quadplex or 4 individual small houses.
Yeah, a lot of it I would really have to really dig into it, to be honest with you. Because it could be, because because it does read, if you read the Home Act, I have to treat any building that's served by municipal water and sewer. If it's a single family home, I have to treat up to 4 units as a single family on a lot. And that's, the legislature too is also in conversation about lifting that further, so who knows?
So
Is there any question whether or not these 4 adding this subdividing as proposed is not allowed? Like how is this
Well,
directly?
currently, the way I read this and read the regs and the state, that 0.3 acres would only be good for 2 residential units.
Okay.
That's how I read that.
That's fine. We're happy with that.
So is the applicant looking, are you coming to us proposing a subdivision of this lot? And that's really what you're looking for here?
Yeah, I would love to know that we could do this. Getting a little bit of guidance on, how many units that you think is realistically zonable for, which I mean, it's 2 seems fair. 4 would definitely be pushing it in terms of where people would park.
Well,
We have to-
so I
couldn't hold you to part.
I think if I read you right, I think you can do something with what you're proposing.
I love
How
that.
much you do and how you do it is what you and your engineers will have to discuss.
Okay, so we're getting a preliminary approval here and we're off
There's no
to,
approval. There's no
Oh,
approval.
okay.
All we're doing is discussing it.
You're not saying no.
Well, that
Well, we
just to
don't
make the
say yes
distinction,
or
the
no.
the next step, when you're going through subdivision process is preliminary and then there's final. So that's why we all jumped and said,
So,
no,
you know,
this
like
isn't
the
preliminary.
first part of this is like you essentially float what you're gonna do.
Yeah.
And the board says, hey, we would have concerns about, which is kind of what I noted in here. It's like, hey, something that
Erosion.
jumped out to me is like, you'd want to have make sure erosion and sedimentation control plans for when you come
Right.
before the board.
Right, and these would all be taken care of by an engineer, by a civil engineer, essentially would take care of all of this.
Okay.
Hmm?
Tyler, how does this, the lot we're talking about subdividing off the condominium is the blue area on the bottom right? Is
That's
that-
correct, yes.
Correct.
Right, what are the boundaries of the condominium?
Hang on 1 second, let me pull that up.
I can show you.
It's kind of weird.
So it's
It's
that red.
this, it's this area, kind of runs up here, runs
Oh,
down.
okay, I see. So
Comes
it's got a
down
bit
here.
of space.
Yeah, it's a weird
It's
lot.
not totally accurate. But
Oh,
yeah,
Are you in a butter?
Yes, she is.
So that
Yeah.
lot, that lot that is.
Sierra, are you in a butter to this?
I'm at 90 Jericho Road, so.
I know that, but your property stretches over in the back there.
Yeah, exactly.
Yeah, so you're up here, yeah, so you are in a butter on the back of your property abuts.
So is this property improved at all now?
Well, there's condo units.
Yeah,
on
at the
it.
top,
Top of the driveway in there.
top of the driveway, there's 8 condos, Leanna.
Here,
there's 9, yeah.
I think I got something that might help a
Top
little
of the
bit better.
driveway,
Hang
tell
on
me
one
where that
second.
is.
Hang on
so-
1 second here.
Oh, there's a good, like, it's called the,
Is
the
it-
site, item 3,
Item
site
3?
plan.
Here, let me get it.
That's not what I want. It is, that's what.
All right,
Used to be a gas station out front, wasn't it?
Yeah, the foundation's still there.
Wasn't, yeah,
It is.
I remember then that was there.
Oh my God, really?
This might help a little bit.
There we are.
So Roger, this is it
There we
here.
go.
okay, I see.
Sorry, let me try and get this box out of the
No,
way
that's
here
all
for
right, I
you.
get
Get
it.
that box out of there.
All right, so, yeah, all right, I see. I got it.
So it's funky, it kind of comes
That's
up
all
a
right, I got it.
ways.
So the new lot that you're proposing would be right off of Route 2, is that correct?
Correct, yeah.
Well, I think the answer is, yes, you could subdivide it, and I'm not sure that we can tell you at the moment how intensively you could subdivide it, but that's something that your engineer and Tyler can discuss before you come before us for a preliminary.
Okay,
But that-
sounds good.
That be something the board agrees with?
Yes.
Yeah, and I'd agree with, Tyler's recommendation to, give consideration to erosion and sediment control. It is a relatively small area. But still, it is close to Route 2 and a lot of adjoining property owner, and then, pay attention to the landscaping plan requirements as well. Certainly potential for impact to adjoining properties and highly visible from Main Street.
Sounds
Yeah, you
good.
might
Thanks,
wanna
guys.
consider trees, but we can go over that.
Yeah.
So are you comfortable with that?
Yeah, I'm glad. I think I understand what I need to go forward, and I'll be in touch with you, Tyler, to hold my some more.
Happy to point you in the direction.
Okay, thank you guys so much.
Did I ask if anybody in the public has any comments or thoughts?
How many, homes are they planning on putting in?
They
I don't
haven't,
know yet.
they haven't asked that. Basically, all they're asking is, can they subdivide off a lot,
No, I got that part, but.
and then they'll have to figure out how intensively they can do it.
The sketch
These can be
shows,
pretty bare bones, like, just to be fair, like, there might not be a whole lot of. There's not usually, it depends, like, sometimes you'll get like a lot of stuff with a sketch plan, sometimes it's very sketchy, how should we say?
the site plan does show 4.
Yeah, we think that's just as a mock-up, yeah.
But that could be 4 smaller homes, they were saying, that 4.
No.
It's where, it would definitely not.
That's what
not-
that's
or
what they were
each
showing.
one. Right, or like 2 duplexes in place of 1, yeah.
Sort of what,
I
instead of
think it
one
was
4
more of a
unit.
placeholder for here's something that we could put here in theory. I don't think they've gone too far into what that would be or how much of it they would want. I think the big argument is, could we subdivide this?
I got that right.
And a lot of that was based on, they have, these condos, when they were built back in the 80s, there was plans to have, I think it was 4 to 8 more units kind of along that section there. And the builder just basically said, I don't want to do it, deal with it. And he just conveyed the land to Village View Associates.
Correct. Yeah, there was originally a mock-up for 4 more units down there.
So that's why you use that, because that's what you had, right?
Yeah, I don't know. The thought experiment. I I think 4 would be a little snug, but.
What
uh,
are the setback requirements there, though?
I think it's
Pretty
20
mi-
from the
pretty
front.
minimal.
Yeah, well, because it's in the VRC, so it tends to be one of the lowest.
Minimal.
Yeah,
Yeah, you're looking at your side. 10 foot for front,
Wow.
15 for rear, and then 10 from the side.
Okay.
that's the,
And nothing from the driveway, right?
No, it would be, the
Existing.
front would be, I would kind of, generally speaking, I would have to make the call what the front is. I would probably say where the driveway is the front.
And how wide
Which
is the
weird.
how wide a driveway would they need? 12 feet?
It'd have to be, I'd have to look, it's funky. I don't know if, because of the condo units, if they'd have to upgrade that to a
Oh,
road.
that's right, that's the same road.
Yeah,
that-
that's a really important point to
It is,
consider when
it
you're
is.
Because
consulting.
then it would have to be paved and then you had to have stormwater for that, so it's, because if you serve 4 more.
Leona, did
lots.
you hear that right there?
that if we shared the driveway, it would have to be a road.
It might be upgrade, have to be
Potentially,
upgraded
depending
to a
on
road.
the amount of units it serves, it hits a threshold.
Do you know
No,
what that
If it's
amount of
already
units is?
there, what's there is there, right? So if they weren't required to build to a road back when you built this, then it doesn't have to be now, but if you're gonna change.
Beyond what the entrance to what the
Yeah.
lot is.
Yeah, you'd have to propose, like, if you're gonna serve like more, you might have to upgrade. I don't know if you'd have to upgrade the whole thing or just upgrade the new part. Again, I would have
Is-
to look at
Is
it.
it paved now?
No,
I don't believe so,
gravel.
no. I don't think it's probably not to what it technically should be, although I don't know, condos are weird and I don't see them very often. So I don't, so I don't know if the same road, if the road standards would apply, because then it would have to be paved and built, certain widths and all that stuff.
Although we can
Hammerhead
give
turnaround.
a waiver on that.
To the paving requirement, you can, I believe.
That would only make the runoff worse.
Okay? Everybody comfortable with that?
So we
Any
don't,
further
we don't
questions?
know. We don't know about the road. Like, we don't know how many units would make us have to have that be a road, right? That's a
Right,
question.
you'd
Yeah,
have
you and me will have
you'd
to
have to
work that
figure
out.
out what, you'd have to figure out what you're gonna do. And then, once you decide what you're gonna do, look at what that requirement would be.
And Leanna, whoever you get to do the work for you, because you're gonna have it professionally surveyed and all that stuff.
Mhm.
Whoever you have putting together the project for you, you can put them in touch with me and we'll meet and go over all that and figure out what you do or don't need to do.
Okay, sounds good. Thank you.
Thank you.
Thanks.
Okay, last but not least. At least as far as applications go.
Mhm.
SKP 2024-06 VYCC. 1949 East Main Street. It's a sketch plan, so there's no decision will be rendered, and the VYCC is seeking an expansion of uses at their property. And they are hoping to add a number of uses to the property, including housing for VYCC staff and participants. Anybody on the board have a conflict with this one?
No.
No,
No.
Okay. Why don't you introduce yourself and tell us what you want to have done. See you, Sarah.
I thank you.
So I'm Brian Courier, Larry Burke Civil Associates, project engineer. Joining me is Brett Knopf from VYCC, executive director. So before we get going in the proposed uses, I talked to Tyler and I would mention that this project was warned as 2 separate parcels, 2 signs, 2 abutters that went out. If you want to put the plan
Hang on a
up,
second.
Tyler,
Let me just get rid of some of this stuff.
the warning, and this is my fault why it got warned this way. But the lot on the western side, yeah, of course. Yeah, so I guess what Tyler's circling, the lot on the western side is a standalone lot. The tax maps show it merged as it's under common ownership, but it is an existing lot. So that was warned separately as part of this application. So on that western monitor barn, there are no proposed changes there that warrant DRB review. So you'll see that
That's the one that was first renovated.
that's correct. That's where the current VYC operations are located. That's their main parking lot. There is a farm stand structure that was constructed, I believe, over the summer, meets ag exemption rules. So that is not part of your plan unit development sketch plan application. So the remainder of the campus east on the remaining lands, the much larger piece, includes a renovation of the East Monitor Barn. You folks have probably seen VYCC working to renovate that structure with the Vermont Historic Preservation folks. It's been quite a summer seeing that structure being renovated, but as it's coming to a conclusion, the proposal is to change the use of that barn, obviously from agricultural use, to a facility that would support VYCC. So it includes a wash pack facility, a commercial kitchen, and conditioned program space. The proposal also includes the Hillside Dormitory, located just west of the East Monitor Barn. So that includes a 16-bedroom, 4-season, 2-level structure to house 16 participants. There's a renovation of the existing farmhouse structure. If you want to scroll down a little further, Tyler. Right along Route 2, it's already a housing mechanism for VYCC, but will accommodate 4-season housing for both staff and participants. And then the hillside cabins are part of the expansion as well. As you can see on the eastern side of the access road that currently exists, there are 6 cabins. Those are meant to be seasonal cabins, but also to house VYCC participants. There's also the horse barn, a existing structure that, or a proposed structure that would be used for teaching and training space. There's an outdoor kitchen located, I believe.
Fire pit.
Yep. Yep, adjacent to the fire pit, north of the existing Quonset hut that would eventually be removed for expansion of the existing parking lot. And the horse barn would be used for teaching and training space. The outdoor kitchen will support participants when they leave campus in the warmer weather months, obviously. And then there's a farm shed, which we talked about already, that will also serve the agricultural fields and uses that already exist on the property.
Now, you have a commercial kitchen in the west barn now, that would be removed?
The commercial kitchen in the West Monitor Barn, I believe is going to.
Where'd that come from?
You want me to jump in here,
That's
Brian?
okay, yeah. Yeah, go ahead, Brett.
Yeah. Hi, everyone. Breck Knopf here. David, your question was wondering if the commercial kitchen in the West Monitor Barn would remain, and the answer is it would stay as a commercial kitchen.
Okay, thanks.
Yep. Brian, are you handing the mic to me here for a second?
Take a run.
Okay, all right. Hey, folks. Thanks for including VYCC on the agenda here. Brian, thanks for a good overview there. What I'll try to do is just offer context on programs, what we're trying to achieve, future vision, if you will. I think it's helpful to just start with a quick recap of VYCC history, because we moved to Richmond in 2005. And it's hard to overstate how the campus has transformed the capacity and impact of VYCC. I think the biggest example is the farm at VYCC. We're now the largest prescription vegetable program in Vermont. We enroll over 450 families who struggle with food insecurity or diet-related illness. They receive weekly shares that are actually prescribed by their doctors, including a partnership with Richmond Family Medicine right here in town. There's a lot of other ways in which the organization's grown and changed over the last 20 some odd years. Our training's more technical. We've got partnership with high schools and higher education. The campus has helped us gain efficiencies because all of our tools and equipment, vehicles are stored on site. And of course, it's elevated the profile of the organization. Back to one of the first things that Brian said, we acquired our campus really in a piecemeal way. So the East Campus, which is about 135 acres, we acquired in 2008, and we've never really completed a campus master plan. And that was a bit of a catalyst for this process, because we are continually finding ways in which our current infrastructure is inadequate and inefficient for today's and tomorrow's programs, really. We're really focused as an organization on making service experiences, paid service experiences, more accessible and of greater value to our participants. And the two primary ways in which objectives that we're trying to address with this plan are the lack of housing. We consistently hear from applicants and core members who say that if VYCC didn't offer any housing, they wouldn't be able to participate. We hear that from folks in the farm program who are in the farmhouse, and the lack of four-season teaching spaces. So imagine trying to teach first aid in an unheated haymow in April. It's pretty rough. And then a close second to those primary objectives is wanting to expand the food security impact. We're looking to expand to a year-round share for those folks who are food insecure. So all this, in our view, feels really good for participants, good for Vermont. I'll speak to one of the clauses in the zoning regulations that Brian and I talked about with Keith and Tyler the other day. Chapter 7, page 101. And it reads that an educational facility, any establishment certified by the Vermont Department of Education, including parochial, private, public, and nursery schools, colleges, university, and accessory uses, but specifically excluding commercially operated schools of beauty, culture, business, dancing, driving, music, and other similar establishments. And if you are an establishment certified by the Agency of Education, there's a cleaner path forward. And so Tyler encouraged us to speak with the Agency of Education to learn what's involved with obtaining certification. I spoke with Pat Gray at AOE earlier today. It was an interesting conversation, and what I learned is that the Agency of Education doesn't certify. The Board of Education approves independent schools. The New England Association of Schools and Colleges determines accreditation, but the AOE doesn't certify. It's not a word that they use. And so her take was that the regulations are asking for an imprimatur that doesn't exist. So we can document ways that we're an educational organization, industry recognized credentials, accreditation by the core network. We've worked with individual school districts to help students gain credit. We partner with CCV, so our crew leaders earn college credit. This upcoming summer, we'll have VYCC be a registered course with UVM, so high school students can take advantage of dual enrollment credits. But the process of obtaining certification from AOE is not one that exists. So I'll pause
Can't
there,
believe-
hear people's thoughts and questions.
Well, I think, and I don't want to jump ahead of the board, but I guess, is it that so what would they say, that they would accredit stuff if somebody else accredits it, essentially? If another organization accredits it, that's how you become an accredited school?
Well, there's a difference between accredited and certified, right? So the state doesn't do accreditation. That's a regional entity, the NEASC, New England Association of Schools and Colleges.
Well, one of the things that our board does is interpret the ordinance.
Yeah.
And if the ordinance is incorrect, surprise, surprise, it would be up to us to interpret what they were trying to achieve and whether you, the applicant, achieves that or not.
Correct.
So if accreditation doesn't really exist, then we have to decide whether what they were trying to get at by using the word accreditation is satisfied by your organization.
Correct.
Yeah, and I would point out, David, that they were approved as an education facility at one point back in 2013. However, you kind of did it in a roundabout ways, that they said that they couldn't get a certification, but they said it was a similar enough use that they did it anyways without the letter. So technically right now I would say they are, as they currently are construed, an education facility. The issue then becomes is, well, if you expand it, I technically would kind of probably view that as a legal nonconformity, that it was approved, but it didn't have this accreditation, so it probably should not have been, but it was never appealed. So therefore, in its current configuration, it can exist as a education facility in perpetuity. But provided that they want to change it, and I guess that's your question as to what do they need, because I have to believe that the accredited schools, the AOE, has some way of certifying schools.
Well,
At
if
some
UVM is gonna let them give credit and accept credit from, which is, I think, what I just heard.
Mm.
Seems to me, UVM seems to feel that they're an educational facility.
Or they're
Yeah.
perhaps an extension of.
I mean, it makes sense. It's just my job is, again,
Right.
there's a hard call out in there that it needs a certification. And if that doesn't exist, I don't know what we
Well,
We
then,
need
but
something.
then,
We'll figure it
that's
out.
what I'm saying, then it's up to
Right.
this board can make interpretations.
Mm,
So Tyler, if they were, let's put this question of certification or non-certification aside for a moment and say they are certified because the board
mm.
said they are an educational facility. Are the proposed changes, do they violate our definition of what you can do with an educational
Well,
facility?
it's squishy, and this raises, I think, other issues as to what does that encompass? Because we have these dorms, right? Which is the bigger, to me, which was the bigger issue, is that we don't have a like dormitory style housing as a use.
But if it's an educational facility, if the use is educational facility,
Mhm.
isn't dorm style use?
See, I don't know if it is. I don't know if it's just the use and the individual buildings themselves that make up of it have their own.
This, once again, would
Uses?
have to be our interpretation of the limits of what an educational facility is.
Yeah.
So we have to establish first whether we consider the expansion part of the expansion of an educational facility that we've already approved. And secondly, whether the uses they propose, the expansion items that they propose, fall within the educational use, and the regulations can't do that for us. We have to do that. Is that what you're saying?
Essentially, I mean, there's other things to consider, because if you want to, and my issue is how do we handle, I think the big issue is the housing, right? Because we don't have dormitory style housing. You could argue that it's part of an education facility, but you could also argue that it's an associated, it's a different use, right? Because what I'm envisioning with this would be, they have to do a PUD anyways to have multiple principal structures on a lot. And if they want to change, if they want to have all these dorms, the question is, are there multiple uses? Meaning you have an education facility that also has a residential component, which is its own uses, or is the residential component baked into the education facility? If so,
Yeah.
what standard do we hold the dorms to? Because we don't have dorm housing. We have multifamily housing, we have single family housing, we have
Okay.
seasonal camps, but we don't have,
But we could come up with something.
yeah, there's issues that you'd have to
Would
work
this
out.
housing have septic?
That's what I was.
Some of it does. The cabins don't have interior plumbing, but there's a community building that does.
Because we discussed this, some use, I clearly remember for VYCC discussing something with them and they wanted portlets.
Mhm.
I really remember that, because we got onto a long discussion of portlets. So I guess this board would be interested in what you're gonna do as far as sewage goes.
Yeah, with the 16 bed, the permanent one must have.
Oh, yeah. We've been in talks with the Land Trust and Richmond Vermont Land Trust, Richmond Land Trust to put a large septic field just north of the solar array.
That's what I was. Yeah.
Right, so we're looking at, roughly a 5,000 gallon per day system, for what we're talking about. So we're not looking at portalets, currently.
Good.
Just to just back on that question about housing and educational facility, just for argument's sake, assuming it's an educational facility, my 2 cents is that the housing is part and parcel associated with that.
Yeah.
I mean, our definition of educational facility includes colleges, universities,
Right.
and accessory uses. So to say your facility can only
I think
includes
my issue would have.
if I could finish, if educational facility, to limit it to just certain structures and say, oh yeah, your housing for your students doesn't cut it. Now, I don't know.
So it's a package.
Yeah, I
looking for
think
That's
the
how I
parse
read
it
it
would
too.
be.
Yeah, I mean, it's hard, Patrick, because again, we don't really have this. And again, so like.
I heard that.
And this is the only thing that we really have, and they're not an accredited college, so that's also kind of makes that a little tricky.
No,
in
but I
terms of
think
that.
I think by way of
I think
example,
we're past that.
yeah.
Well, the question would be, what would you want to have? Because if it's housing, typically how I would approach housing, right, to be a dwelling unit, right? At a minimum, it needs a living space, a bathroom, and a food preparation or kitchen thing inside of each thing. Now, you could argue whether or not
That's
each
not
cabin could
typical
get
of
away with
college.
one, right? And I mean, at least from my college dorm experience, we did have a community kitchen, at least on pretty much in every floor that was a full kitchen.
Yeah, that's
Could
true.
use.
I went to school.
At least where I went to college. Now granted, they were not all the
We
same.
had no kitchen facilities when I went to school.
That's why your school didn't cost $70,000 a year to go
There's
to.
2
Yeah.
commercial kitchens on.
Ohio State.
That's what I was gonna ask you. There's.
Yeah.
So there's
I'm
one,
pretty
there's
sure
one
those
close.
folks are eating. I'm not too.
Yeah.
worried.
Yeah.
Lots
They're
of
probably
pizza.
growing.
Lots of
Lots of
pizza.
vegetable.
Lots of pizza.
So has there been a discussion about how many bathrooms and or showers there'll be in that permanent 16 bed? I'm sure there's some kind of statewide
Yeah,
Like-
it's not by bathroom or showers, it's by bedroom.
bedrooms,
So the
right?
bedroom counts will be considered, and any shared facilities, would be, gauged by participants.
Okay,
We've done those numbers and we're roughly in a, 5,000 to 6,000
Okay.
gallon per day
That's-
system.
Where those cabins are, that's pretty steep in there, isn't it?
Yeah, I think, just north of, the road shown there is an existing access road.
okay.
So we would be just above those, but those would be pedestrian.
I mean, you have the power lines up top there, right?
Right.
Those all meet the setbacks because it looks pretty close to but I don't know
Yeah,
specifically.
so this line is an easement line.
Okay, very good.
This line is an easement line,
All right.
and that's why I thought this was an easement line also, but this is actually its own lot. So there's no setbacks associated with a easement. When this land was, correct me if I'm wrong, Breck, but when this land was purchased, it was purchased with dollars from land trusts, multiple land trusts. So they.
Yeah, I can't see what you're looking at, but yes.
My screen
It's the
shared.
easement line just north of the most northern cabin that we're close to. I'm describing that's an easement line to the land trust.
Yeah. Yep,
That
yep.
helped purchase the land, not a property line for setback purposes.
Yeah, if you're you got the line that I think you're looking at, there
Trying to
are,
move the cursor along it.
Yeah,
What type of
Or-
an easement?
I'm assuming it's a conservation easement of some
okay.
kind. Yeah,
I see.
right. Development rights, those sorts of things. But we were able to gain,
But you own the land, not the land trust.
we own the
Correct.
land,
But-
the land
but-
trust have an
But it's
easement,
subject to a conservation easement.
correct, and there's
Okay.
multiple easements, there's, was there 5, Breck, maybe?
it's too many to count.
Yeah, there's the Richmond Land Trust, Vermont Housing and Conservation Board, Natural Park Service, Farm Bureau, Vermont Land Trust, Richmond Land Trust. There's quite a few
It's
stakeholders.
got about 100 pages of easements.
Yeah, but
So those usually limit development rights, but it doesn't limit it because.
so that's only up to,
Below-
that's only up
below the
above.
easement.
So
Okay.
below is
That's what I was-
not covered by those, and is where all the existing structures exist now.
Yeah, and one other thing too to recommend, what makes this thing weird is that it's got two different zoning districts in it. So this area is actually in the commercial zoning district. In the area more or less kind of north of this dotted line, it's not exact, doesn't exactly track, but it's kind of close. That's ag up there. And where this gets tricky, depending on what you want to do with the housing units, is that residential uses are restricted there. And if you do a PUD, you can't have a residential PUD in that district. So if you have a PUD, the housing has to be on the second floor of a building or above, so the ground floor can be commercial.
So I was responsible for getting that commercial zone in there. Because my client owned the whole farm, said Wheeler. And he wanted to rent that one house out to this guy who had a commercial use, so we
Okay.
talked, convinced the planning commission in those days
Yeah, yeah.
to do a commercial zone, of which they thought it was spot zoning, which it probably was.
Yeah.
Water under the dam.
You should get a plaque there too. Tom Hart's got one.
But PUDs were.
Had forgotten about that.
The housing unit.
Because in order to have multiple principal structures on a lot.
Yeah.
You have to have a PUD.
Even if it's an educational facility.
Yeah,
they're
it's
building
still
dorms.
considered.
So the way we've been looking at this is the multiple so it's multiple principal
Principal
structures,
structures,
right? So in our opinion, that's the East Monitor Barn, you know, farm barn, the carriage barn, you know, the primary VYCC
Mhm.
teaching educational buildings. And the residential component, which I don't like using the term residential in this case, but the dormitories are accessory to those primary uses. So it's the multiple primary principal
makes sense.
structures
Mhm.
that trigger the PUD, and then the residential don't need to be considered as a PRD. They can be approved as accessory to those multiple principal structures on a single lot,
Yeah.
is how we've been viewing this.
But the problem that you run into with that is that there are restrictions on where you can have quote unquote dwelling units in a PUD, and you can't have a residential PUD in a commercial district.
Not a res.
That's what I'm saying. I don't think.
But you
it's a
can't have
residential
dwellings,
PUD.
if you can't have people sleeping in accessory buildings, that's not a use. So again, that's what we gotta try and figure out.
You know,
This is
if
weird
the
thing.
commercial district causes you issues, you might think about going back to the planning commission and.
Well, I think,
Yeah, we get rid
the
of that.
educational facility is it is a conditional use, right?
Yeah, that does
It's,
require.
it's not permitted, but it's conditional, and the fact that the educational facility exists on the site today takes care of a lot of the conditional use criteria, and then there's past, decisions by the board that essentially say that, yes, it is a educational system, and what was approved there was the use, not the intensity of the use. So the fact that the use is being intensified and was deemed permittable at that time in 2013, I don't think that the intensity piece of it is only considered if it was non-conforming at that time.
Also, that under the exemption section of the zoning, right, it says. No use shall be allowed except for those uses specifically mentioned as being allowed. The DRB may, on appeal or in considering a conditional use application, allow a use which finds substantially similar to a use specifically mentioned.
Yeah, good point.
So, I mean, between that and the inexact language regarding educational facility, I think, we could certainly hear an argument.
Yeah.
Based on all that, facts that Breck was mentioning.
Yeah.
To make the case, and, I don't disagree, that there was probably some reason we previously designated as such, although that is not binding, of course.
Sure.
I don't speak for the whole board, but I think it's been great to have VYCC in Richmond.
Yep.
And I think it's a organization that is needed in the state. And you know, I find this the fact that you want to move forward, exciting. I think you're gonna have to do some planning
Oh, yeah.
with your people and with Tyler.
Mhm.
And get an application in front of us.
Yeah, that's my primary concern with it is really, is the
Housing
forms.
part,
That's to me the 800-pound gorilla. The rest of it, I think we could take care of pretty cut and dry through a PUD. It's just the issue is what is encompassed in an education facility if it's deemed that, because if it's a PUD, you can have multiple uses, so you could have an educational component, right, which is an education facility, but are the dwelling units,
I
I
think we
don't
can-
like calling them, are they their own use that's on this property? Are they a part of the education?
I think we can speak to
Facility?
that though, right? That's kind of becomes our preview at that point.
I
So,
think, yeah.
yeah.
Could you subdivide them off and sell them as residential units?
No.
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 Are they allowed as part of a educational
I
facility
think
for
that you're
temporary
arguing
student
for-
housing?
Agreed.
Anything else from the board that the board wants to,
No. We're beating it to death.
does that give you enough food for thought?
There is one member of the public still there.
Oh, I'm sorry.
Just in case.
Gina? Do you have any comments from the public?
No, nothing for me. I was just here as an interested neighbor to see what was going on. And I mean, my question was more about what they mentioned early on about the farm shed, because that was mentioned in the paperwork. It wasn't mentioned as part of this plan tonight. I had one quick question about the farm shed. Can I ask that at this time?
Sure.
Um,
When
what
you say
I-
farm shed, what are you referring to?
So the one that
over here, Gina?
is, yeah, yeah, thank you. I'm just wondering what the uses are for that.
So
Sure, I can jump in here. So
Thanks.
just to clarify for the DRB, the farm shed is already constructed. We secured an Act 250 permit for that last year. It's an agricultural structure. And a crew built it this year. If anyone wants a tour, I'd be happy to show it. So Gina, that's gonna be for primarily for tools and equipment storage. So I could see things going in there like plastic for the farm, you know, various farm implements, tractor implements. There's one bay that's heated, so if a tractor needs repair when it's cold outside, we can bring it in there. Things like that. Does that answer your question?
Yeah, I was just you're just saying tools and tractor?
Tools, equipment, tractor. There's a
Yeah.
little bump out on the north end that you could probably stick some picnic tables under.
Mm-hmm.
You know, I don't know if my list is exhaustive, but those are the things that come to mind. I think Jake's interested in moving stuff in there over the winter and early spring.
Okay, thank you.
Yep.
No other questions for me.
Thank you, Gina. Appreciate
Thank
that.
you. Yep.
Okay,
thank you.
Thanks.
Appreciate it.
look forward to seeing an application.
All right. Thanks, everyone. Really appreciate it.
Thank you.
Thanks.
Tyler, well, the discussion in the Richmond Code of Ethics.
Sure. Well, I guess it's more or less, you know, your guys' so per our ethics policy, we're required to have a conversation in a public meeting about the Richmond Code of Ethics at least once a year. So hang on a second, I'm gonna keep sharing this so in case members, anybody's watching this later can see it. Before I get too ahead of myself. There it is. So I guess my question is, I'm assuming that you all have read this more or less. Some more, maybe less, but and just was curious if you guys had any questions, comments, concerns about it. The only requirement is that we talk about it in a public session once a year. Does anybody have any questions about what construes a conflict of interest of any of the board members? Kind of how we want to administer it is more on our rules and procedures, but we are bound by this. And also in January 1st, Patrick probably knows about this. There's going to be a statewide code of municipal ethics, which takes effect January 1st, which may supersede this. But that is what we were going to be held to, and we'll follow a similar process. So we're supposed to do this once a year, so we're here to talk about it. Doesn't necessarily say how in depth that has to be. Maybe one thing like this ex parte communication thing, if I could talk about maybe that to me, I think in some instances, there may have been communication, I think incidentally, by people feeling out members of the board about how to proceed with certain applications or what they should apply for.
I mean, truth be told, I get a call about once every 2 weeks.
Yeah.
Wanting to talk about something in town.
Yeah.
And I make it very clear that I can't have ex parte conversation. I also don't hang up on the person.
Right.
But mostly I direct them to you.
Yeah, and I think, and that's the proper way to kind of, I think, to do that. And I think we had another thing that kind of came up today, like if people are communicating with you guys individually, I think about questions about an application or thing, feel free, I think, to direct them to me because it's my job. And I'm not trying to, you guys are more than capable for speaking for yourselves. I'm not trying to say that, but I'm kind of the gatekeeper. I'm kind of the referee, more or less. And that just because you might have a personal relationship with somebody may feel more comfortable coming to you and asking, just feeling out how you should go about doing stuff. And more of that should be funneled to me. And then I'll kind of tell them, one way or the other, just to try and make sure there's that wall more or less between you guys and the public, just so there isn't even a perception that there's, off the books, even if it's just informal advice as to like, for conditional use applications, you should submit X, Y, or Z, or you should go see somebody, which is pretty innocent. You're not really talking on the merits, but that's kind of like flirting with it. So maybe just try, and I'm not telling you guys what to do, but just maybe ask that question of whether or not if it's dealing with the rules, the procedures of how to get to you guys, it should probably go to me. And I'm more than happy to field that. You can give out my email, cell phone to as many people as you want. I don't care. So I think that's my only thing just to maybe watch out for, I think, because that could kind of be a little innocent, but it's easy to kind of do. And
Would this be, would this be if there's already an application pending in a meeting? Or if,
Could be
somebody off the street is just asking me about developing land? I'm a developer, right? So it's kind of like, what would be considered?
well, I think this is where we start to get into it, right? It might be innocent, right? But then let's say they come in with an application before the board, or maybe they're approaching you about building it.
Right.
Right now, that's kind of a little,
Well, that's why, again, today was like a perfect example about, I talked to you about that earlier.
and again, I think fairly innocent, but I think that's, I also think of some other, I know people have had conversations.
Everybody.
Yeah.
Well, there's another thing too, not so much with this, but like with Andrew's Community Forest, I know there's been a couple people that have reached out to various members of the boards, or at least that's what I've heard one way or another. And again, even if it's pretty innocent, it's kind of like, if they're seeking advice on how to proceed with something, it should probably come to me. And I get, it's obviously your guys' judgment call, you're all adults, you gotta feel, if you feel that it's not an issue, then go with your gut. Obviously there might be some repercussions to that down the line, but again, I urge you to exercise your good judgment. And if there's a question, maybe just send them to me, just to be safe.
I don't disagree, but perhaps there's a distinction to be made between, this conversation started out about, ex parte communication. And if someone approaches us and says, hey, I saw on the agenda, there's going to be this project. Sorry, I can't talk to you, talk to Tyler if you got questions about anything. If someone approaches Matt, knowing he's a developer or any of us,
Or whatever.
lawyers, whatever, and they start talking about a project that no one's applied for, it's not on any agenda, and like, hey, do you think I could subdivide my property? And if I want to have that conversation with them, that's not inappropriate, that's not ex parte. If at some point, an application comes up, then we have a conflict in potentially. In all likelihood to disclose.
That's what I'm getting at.
Okay, so but you were saying we shouldn't talk to them. So I guess perhaps sometimes they get so involved, absolutely. I mean, I wouldn't hesitate to send someone to you at all. But I just think there's a distinction to be made there.
Yeah.
I feel really left out. I've been on this board for almost 9 years. Nobody's ever asked me anything.
Not even your wife?
You
No,
No, and I didn't mean that in
must
like,
get stuff from work. You must get people that call you.
People call me about Richmond stuff?
No.
Or- Oh, outside of work, people ask me
Yeah.
about work? Yeah, I mean, that has happened, but that, if it were ever to go to, trial or something like that, then there's something to disclose, but.
and I think your point is more or less what I was getting at. It's like, just be aware of the fact that like, it's like, if you have a pretty good feel that somebody's submitting and going to submit an application soon, and they're kind of like trying to get a read on how you would interpret it or how it could be interpreted.
Agreed.
Maybe that's more what I was getting at.
Okay.
So
Right.
Yep.
I think that's something just to bear in mind. Obviously, use your judgment, right? If it's
Always do.
pretty academic, like, gee, could you subdivide a piece of land over here? It's like, yeah, I think you could do that based on this, or like, hey, this lot off of Johnny Brook Road that's located here, what would you see as problems with that, right? That's where we're starting to maybe creep into that.
I do have a question in
That's a
a
real
different,
cluster, that one.
in a different area.
Mhm.
And I appreciate the opportunity to have this conversation. I did read them. If one of us are absent for a hearing, so then there's no, and then we have the hearing, we make a decision.
Mm.
The absent individual does not participate. Is there any need to disclose the conflict? And if so, what would the form for that be? Do we contact the chair to say, hey, I'm not going to make it, by the way, I have a conflict of interest with this application.
Well, but you're not sitting on it.
I'm not
so-
sitting on it. I just want, it's like, I
So
appreciate.
that we could do that in our rules and procedures about how we want to handle that, maybe, if we feel it's
I
something.
mean, I think a black and white read of it. There's nothing, you don't need to, and I don't think anyone would want to, be, would.
If you're not
not want
sitting
to
on
dis-
it or acting, I think to your point, there's no,
You're
if you're not weighing in on it, I don't think you have to disclose
Okay,
it.
that's
Yeah,
how
you're absolute.
that's how I would interpret it, but one of the.
I would as well.
Yeah.
Did you guys want to have any more questions about specifically the code of ethics, or one to the rules and procedures?
Let's go to the rules of procedure. Anybody have any? I read them over and,
And my document was really meant to be more of a discussion, like what highlight some things that I thought might be merit discussion. You guys obviously can get your own things, but it was just more of meant to be a conversation starter.
As far as minutes go, if we don't, I'm on a number of boards.
Mhm.
And the most boring part of every board meeting I go to is the minutes from the last meeting, where people get real picky, blah, blah, blah. So I think I like your suggestion where if we don't need to approve minutes, I would say the only time we deal with minutes is if someone objects to or has a problem with what the minutes were from the last meeting.
Do we want to have a carve out and not necessarily approve them, but maybe at the beginning, it says, maybe not, I guess if you're gonna do that, you might as well vote to approve them. I guess maybe you could say that. I guess how would we
So-
we want to do it?
My experience is 80% of the people do not read the minutes. And when you say, okay, let's review we gotta vote on approve the minutes from the last meeting. Everyone pulls the minutes out, starts reading them, and then we get this long delay. So if we don't have to approve minutes, I'm very much in support of that.
State statute is actually very ambiguous as to, you have to have minutes, and it says what they have to be. And it says, but it doesn't say that you have to affirmatively vote to approve them at each meeting. That's kind of like what a lot of boards do, but if you are okay with me just drafting them, and if there's a problem, if somebody happens to read it and they have a problem with the minutes, you know, I'm sure you could,
I personally am fine with that, but
Yeah.
I can't speak for the rest of the.
I agree with that too.
so you're gonna deem them basically approved, basically, once I draft them and post
Unless
them if
someone
there's a
brings up a
problem.
Yeah, and I'll,
They post them, you're gonna post them or circulate them to us? Or you're
I
gonna
have to post them 5 days in advance. I have to post them legally have to post them 5 days after calendar days after each
But you're
meeting.
not gonna circulate them to us, you're just gonna post.
I
them
usually just post
on
them.
the site.
That's how I do it. And then if you guys want to read them,
That's fine,
on
I just
site.
wanted to know what you're gonna do. That's all.
that's how I've been doing it.
I think that's fine, personally.
yep, agreed.
Yeah.
I've appreciated that. When I started, we used to go through them.
Right.
I don't know whose stroke.
I
of
think, and
genius
it's
that
come
was.
up
It
once
was
or
Keith.
twice.
It
I
was
think,
Keith. It
I
was
think the
Keith.
only time it's come
Keith,
up,
Keith definitely hates minutes.
well, to be fair, Keith was actually, I think, was concerned, was interested in us maybe like approving the minutes because he was surprised that we hadn't. And I'm like, well, and I was advised this by Revy, which is why we used to do it at the beginning. And then Revy was like, you don't have to do it, but we
Yeah, that's
never,
right. Revy was the
but
one.
we never voted
Keith
to actually,
took the minutes down.
Yeah.
Yeah.
but we never voted to actually like do that at any point. So do you want to make a? Because I think in here, it doesn't necessarily say it.
I think we're good as we are. We just need to
Yeah.
clarify what we're doing.
Going to the next point about public speaking. I don't particularly like, I know why the select board does it. I'm not particularly, for our purposes, like the fact that you have a 5-minute introduction where public can say anything you want, because you get people who just ramble on, and I would rather just do it the way we've been doing it, which is that on a hearing by hearing basis, application by application basis, the public that wants to speak to that application should speak.
And does the select board do it that way? Just so folks don't,
The select board
Have
does
to.
They
it,
have to do it.
oh,
I
they
think. They
they
don't
have to do it that way?
and also I think they found that that was the fastest way to cut people off who were on to get on a soapbox and just keep talking.
But you could do that either way, right? Whether
You
you're-
could have it at the be front loaded or back loaded. You have to have a general public comment period.
Yes, I guess I don't know. I don't see any advantage to doing public comment in advance because they haven't heard.
Well, I think it'd be more like if they have a problem with how the board's running, right? Or if there's a concern about how you like, it's not necessarily tied to an application, but they're like, hey,
Oh, that's.
at the
okay,
last
okay.
meeting, you guys cut Jan off or whatever it is, and I have a problem with that or whatever, right? It's, or if it's hey, we wish you guys would do, I've been I forgot to post this on Front Porch Forum, this particular meeting, right? Which I'm not required to, but I try and do that.
That I could see doing it upfront. I mean.
Yeah, like, or
I-
like say.
All my time here, I've never had someone come here and say. Offer something not related to, I mean, I'm probably forgetting.
Which is
something.
weird because we're a quasi judicial body too. We're not like an advisory committee and we're not the legislative body. So we're not exactly the same, but again, it's your call whether you want to have like a general, like, and again, I don't think it needs to be like 30 minutes, like Festivus airing of grievance sort of thing, but just, do you want to provide some time for for something that isn't on the agenda?
I don't.
About the Tyler Festivus hour.
No, I agree with you too. We already would just
People can get on the agenda if they want to be, if they want to break something up, right?
I agree.
Yeah.
Going on, hearings cannot exceed 30 minutes.
It must be an exemption.
That's a hard language thing because it's
Yeah.
in there. So do we
And
should want to remove
It's
it?
gotta be on a hearing by hearing basis, and I try, I mean, if we have a long agenda, not, today wasn't too bad because it was mostly sketch plans.
Mhm.
But if we have a lot of agendas a lot of applications where we actually are gonna have to take a vote. 30 minutes sounds good, but I hate a strict limit of 30 minutes. If 5 more minutes is gonna end the damn thing, why continue it? And then the other side of the coin is, and the best example was our first sketch plan hearing for,
Yeah.
the farm out on.
Yeah, Wolf Lane there.
Huh?
Farm, that's not a farm.
Subdivision out on.
Don't worry about what it is, Roger.
Whatever that is, people just Talk.
So why don't you just say, the hearing cannot exceed 30 minutes or should not exceed 30 minutes unless the chairman, at the chairman's discretion.
Well, yeah, because
Yeah.
right now you're supposed to vote on it, whether you want to extend it. That's the language. If you don't want to vote on it, you can leave
We
it
don't
to
wanna
the chair's
vote on it.
direction.
Leave it to the chairman's discretion, and then you don't have to worry about it, but yet you can hang the 30 minutes on somebody's head who's running their mouths. And say, look, we only got 30 minutes. You know, you said the same thing 35 times. Yeah,
No, I
you
agree.
get where I'm going here. So I think that if you added that language, then
And not to back up a little bit, I think my goal of having this conversation is to get ideas for what you would like to do. And then I gotta find the Word version of this doc. And then I could mock up some language, because we should probably have that warned for the public too, if they have some comment on
Oh,
how we
yeah.
run the meeting. We should
definitely.
probably have to do that. But at least that way we can, I'm looking for some guidance as to what do you guys are interested in changing? You can make a motion at the end, I think, to be like, for me to draft language to address what we talked about, and then I could go from there and give you guys a red line for the next meeting or whenever we think we might have time for it. And we could put it on the agenda, and if we continue it to another meeting, we could continue it to another
I mean, to
meeting.
make definite changes on all of this would definitely, do we know the agenda for the next meeting yet?
It's gonna be a robust one so far. We've got
Oh.
David on. We've got, Brown's Court is gonna be on for the pickleball.
Oh, we're gonna have a lot
Pickleball
of,
We're still
fest.
live, aren't we?
we're gonna have a lot of public for that one.
I'm still we're working on,
Yeah.
I don't know where ECF is gonna
Finding
be. I'm
me.
working on some.
Okay,
trails.
so I basically is like, this would be really nice to deal with a meeting where
Flow.
we only had like one applicant or whatever,
Yeah.
one.
But I could throw it on the agenda, and if you want a motion to continue it to your next meeting, you could just, it's under other business, you just motion it to the next meeting. You could keep doing that, I think.
Do we-
either that, or since we know we're gonna have.
Do we have more than those two hearings for January?
I'm trying to think, I feel like there's something else that I'm just not remembering.
Let's put it on for 2 months from now.
Yeah.
Well,
put it
also
on.
that, I also don't know when your stuff's gonna come in.
Well, that's such a great question. Should we be,
We're on live right now,
Yeah.
so we are on the record right now. so.
yeah, man, I don't know if that's.
Potentially. 4 members needed to pass a motion.
Almost might be hard to have that sometimes. We barely had.
I think
4
this
here.
was envisioning when the board was maybe a different size.
Yeah.
We should probably, if you guys don't want that, you just want it to be
I
a,
thought it was 3.
I thought it was 3 too.
this is the point,
thing
we've been
we've always had
operating
for.
with that, and it has not been the.
I think it's
has
simple
not been
majority
as
makes
big.
more sense.
Because we've been operating
Majority of those who are
on that,
Present, simple.
and even though
And
that's
you
not
need-
technically what
and you
we're
need a
supposed to be
quorum.
doing.
Yeah,
So it's the majority and a minimum of 4 currently. Well,
We have a quorum of 3, right?
Yes,
correct.
we need a minimum of
'Cause
3.
There's 5 of us.
Yeah.
Is that correct?
If you have a quorum of 3, how could you have 4 required to?
Well, that's what it says in it, it's just a,
Well, I think the first time I ever came before this board, like, I don't know, it was probably 8, 9 years ago. It was almost double the, not double, but there was like 7 of you.
Yeah, we've had 7.
Yeah.
so which
that-
is why the 4 was there.
Yes. Yes. It's hard these days to get 7 on a board.
But 7 would be very unwieldy.
That's almost.
It's-
True.
The planning commission sometimes has problems with it. Although they're supposed to be getting another members. So, let me see, what was it?
As far as public comment, it's
You
3
wanna
minutes.
change that to majority or quorum? How do you wanna
Yes.
do that?
Majority.
Majority.
Majority of the members.
Majority of the members present.
Present.
There's only 1.
Well, that's what
Well,
I'm saying. We
You
want,
gotta have 3 because it's a quorum.
You can only have, never mind.
King in the castle.
King Roger comes in and he
Yeah.
decides all zoning decision, all DRB.
He's done real fast.
Come on down.
Really fast day.
The expedited permit review? No, just kidding. So present, so we want to change that to 3. That's pretty easy. Let me see here. We had a whole bunch of stuff was terms of meetings are supposed to follow the orders in A through Q.
I looked it over. It's sort of the way I do it. I thought, I was surprised, actually.
Is it all right, like, cause I kind of mocked this up a little bit by, I might make, this is kind of a test run for the agenda of building in that dedicated, like, disclosure of potential conflicts of
No,
interest
that's
ex
fine.
parte.
Nope, that's good to have it there.
Okay. So far, the only language changes I kind of have were the changing the 4 to 3 and then the
Majority.
majority. The public comment, which was like 3 or 4 minutes, we don't keep track of that. Do we want to do it at?
No, and
discretion?
you know, I'll cut people off if they're really, I mean, I try to keep repetitive comments where it's the same comment over and over again out of the way, and I'll call people on that. As far as timing, I know the select board is pretty strict about 2 minutes.
Yeah, because I don't keep time. I could get a clock to do that.
Now,
Oh, God.
I'm just trying to serve you guys what you guys want. So,
We don't want that.
okay.
So,
site visits, I'd like to go back to a site visit the way we did it. So if we have a site visit and everyone comes, it's a meeting,
which has to be warned,
which has to be warned.
Yes.
or just have one person. go.
And
You can't talk, the public, nobody can participate, but they
Yeah.
follow you around as the applicant walks you through the process.
Yeah.
I thought the way we did it, where we set up a list and we assigned one person to be the liaison, and that person went and visited the site
And then reported.
and then reported back. I sort of like that system.
I do too.
That's how you guys did it with me years ago
Yeah.
when I was doing a project.
I think I've only been on like one site visit.
We have not done one, we've done one
I'd like
since
to,
you and me did one a long time ago.
we did a couple. We did one off of,
Like when I first started, we
yeah.
did one.
I'd
I
like to
think that's
go-
the only one we did.
I'd like to go back to that system, and if you could keep a list, Tyler, and we'll just rotate on that list.
Okay, so we will do, okay, so of site,
Liaison.
Yeah.
Call
Yeah.
liaison.
The question is, when do you do a site visit? Do you do it on a preliminary?
Yeah,
You don't do it on a sketch plan?
no,
No, yeah.
it'd be conditional use, it'd be your site plan review, the preliminary sketch, PUDs.
right.
Okay.
I did a couple, did.
I think it's good to get an eyeball on stuff.
I like that too. I like that, but you know, you can't help talking about what the guy wants to do when
You gotta say a few things. You just gotta tell them that they need to move. You know, what I always used to do is say, show me what you have in mind here.
That's what I did. I mean, and you kind of, it's kind of common sense. You meet the guy and you know him, but I always had to meet him. And I'd say, you know, I'd be walking along, I'd say, tell me what you have in mind, because I have no idea what's going on here, you know?
Well, I guess my question is, what would you like from, as a result of that? Like, cause you guys walked around and then would you provide?
Well, then,
each
and
member
then,
provide-
then when I open the meeting, I will say, does our liaison have any comments? Why don't you describe what you saw?
And you guys would provide that
like
on your
that.
own, meaning that I'm not gonna draft this. You guys would, whoever would delay, I
Yeah,
would be
no,
with
you don't, you don't need it.
but you guys would just to be there. But
Yeah.
you guys would draft your own, whatever you wanted to
I
say.
mean, take Matt's
Hmm.
application.
Yeah.
A liaison would go there and take you 5 minutes to show people what it is, because it's basically all there. You can see it, whereas some of the larger farms like Chucky Farms, 8 lots, or, you know, you'd want to walk through there and
Mhm.
take a look. And Tyler, you and I went to one where off of,
The wet's that wet spot.
it
yeah,
was,
I
it
remember
was really wet. There was a section that was really
that. Yeah, I remember
wet.
that. Yep.
Yeah, I was at one of those, I think it was for FAR when he developed up here.
Phase Corners, was it?
No, it was up there on the hill somewhere. I can't remember.
Yeah, it's,
I mean, this
it's,
is years and years ago, but he had a wet spot and he came to the meeting, he tried to describe it, and I said, well, I remember that, and, you know, you can make the connection.
Yeah.
And then kind of help everybody along with it, and then the board will be better represented, I think, by having someone that has done a site visit, because I can say, oh yeah, I know where that is, and I saw that, or I didn't see that, or, you know.
I think having the full board goes there, it adds more weight to it because it's not in somebody's opinion. It's a matter of fact and
Wait
public
a minute.
record.
You have to warn it though, if we all go there.
No,
don't
I
you?
know, but that's
Yeah,
the
We're not
point,
all-
but
we're
like
not-
we're a liaison, it's just that person's interpretation.
right.
But I think it's much more practical than having everybody.
I know Underhill, they all go to a site visit and it gets. less
Morrisville
and-
does the same thing.
It gets less and less every time. You know, you're gonna have someone there all the time. Who's eager,
Yeah.
but
We can't even get everybody to come to the meeting. We're not-
We do pretty good. I mean, most of the time.
Get them in the elevator.
You guys are chasing each other. It's like,
Well,
oh,
I was worried there for a minute. I'm like, please don't tell me we're gonna have to continue Matt's again. Because I don't have a quorum.
I'm sorry, it's my fault. I was having
Oh.
trouble
Well,
getting,
you're usually pretty punctual.
well, I couldn't see. I was driving down the road totally blind.
yeah,
Yeah,
why
it's not good.
kidding?
I might,
This is the thing, why?
So,
why is it
being,
so
being
much-
mindful of the hour here, like I
Yeah,
said,
let's
is
get
there
going.
like,
Let's go home.
you wanna,
Sure.
notions, wait, so we don't want the 4 members. So far what I got was we want some language changes. So how about this? If you guys make a motion, right, for me to kind of come in here and draft some proposed language changes to the DRB rules and procedures, you could take a look at it. If in doing that, I notice some other things, I could maybe draft some other language to tweak stuff. You guys can take it for what it's worth, not do that. But we should probably take a formal motion on that, not just have me go do it ad hoc.
No, thank you. So moved.
Second.
All in favor?
Aye.
All in favor of ending this meeting?
Aye.
Aye.
Take
Thank
this
you
off.
all. Have a happy holiday.